Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. The judge has issued another ruling in the Blake Lively versus Justin Baldoni case, and this is regarding a motion to compel. Blake Lively is seeking communications between the Wayfarer parties and reporters, content creators, etc. Her motion has been granted in part and denied in part, so let's take a look at what the judge had to say. Blake Lively and Ryan Reynolds moved to compel the Wayfarer parties to respond to certain interrogatories served on March 14th. Lively and Reynolds seek to compel responses to 3 interrogatories. The first, the account interrogatory, states, identify any email account from May 1st, 2024 to date in which any third party, including but not limited to content creators or the media, had access for the purpose of communicating information of any kind, including messaging, talking points, guidelines, scripts, or other information regarding Ms. Lively, Mr. Reynolds, the digital campaign, the CRD complaint, or the actions. And remember, Blake Lively and Ryan Reynolds are accusing the Wayfarer parties of doing some crazy Al-Qaeda shit with these email accounts, where they're transmitting information but not transmitting information. Sounded a little paranoid to me. This interrogatory was propounded by Reynolds to each of the Wayfarer parties, except it ends with us and TAG. And TAG is the agency group, which is Melissa Nathan's PR firm. While Lively and Reynolds' motion to compel was pending, the court dismissed the Wayfarer parties' claims against Reynolds, granting leave to amend certain claims. The Wayfarer parties agreed that TAG would provide a supplemental response to the interrogatory, and TAG did so. None of the other Wayfarer parties have responded to the interrogatory. The Wayfarer parties object that access is impermissibly vague. The motion to compel is denied as to the account interrogatory. The wording of the interrogatory is sufficiently specific to enable a targeted response by the Wayfarer parties. However, Reynolds is not entitled to responses to this interrogatory because he is not a party. As a party, Reynolds would be entitled to discovery relevant to any party's claim or defense, but there are currently no claims or defenses in the case in which he was formerly a party, and therefore nothing to which discovery would be responsive. The mere possibility that an amended complaint may be filed is no basis for the court to compel discovery regarding issues that are not pending and may never be pending before it. Reynolds may renew the motion if, after the filing of an amended complaint, the requested information is relevant to a claim or defense in an action where he is a party. And if they do amend their complaint, that's going to be due on Monday, I think. The second interrogatory, the reporter interrogatory, states, identify all reporters and news or media outlets of any kind with whom you have communicated in any manner concerning Miss Lively, Mr. Reynolds, the CRD complaint, the actions, or the Lively Reynolds companies. This interrogatory was propounded by Lively to all parties. All of the Wayfarer parties except Nathan and Abel have responded to the interrogatory, but have limited their responses to the period between June 15th, 2024 and December 21st, 2024. Lively seeks responses through the present for all parties. And I'm pretty sure that's because she alleges this, defamatory smear campaign is ongoing. The motion to compel is granted as to the reporter interrogatory. The Wayfarer parties have provided no justification for withholding the responses of Nathan and Abel regarding the period between June 15th and December 21st, 2024, and in fact agreed to provide such responses. Regarding the period between December 21st and the present, the Wayfarer parties object that although the amended complaint alleges the smear campaign is ongoing, it does not assert any claims by Reynolds or the Lively Reynolds companies, and that the pleading cites to the communications at issue. These objections do not provide a basis to deny the motion. Although the amended complaint does not assert claims by Reynolds, it asserts that the attempts to discredit Mr. Reynolds were part of the campaign against Lively after December 21st. And although it cites certain specific statements made by defendant's lawyer, it also states that defendants themselves continued to be involved after December 21st, framing the campaign as a continuation of events prior to the CRD complaint. The Wayfarer party's engagement with media outlets after the release of the CRD complaint is relevant to the truth or falsity of these allegations, and the Wayfarer parties have not raised any other objections. The third interrogatory, the content creator interrogatory, states, identify all content creators with whom you have communicated in any manner concerning Miss Lively, Mr. Reynolds, blah, blah, blah. And that's from May 1st, 2024 to now. This interrogatory was propounded by Lively to TAG and by Reynolds to the remaining Wayfarer parties. Lively and Reynolds have agreed to define the term content creators to mean any individual or entity who seeds, generates, creates, or influences social media content, or provides related digital or social media services directly or indirectly at the request of or on behalf of any Wayfarer party or their agents or affiliates. The motion is granted as to the content creator interrogatory propounded by Lively to TAG. Defined as stated above, the interrogatory is not hopelessly vague or unduly burdensome. It does not include any person who can generate, create, or influence online content, but only the much smaller subset of those who do so on behalf of or at the request of a given Wayfarer party. So it can't just be anybody. It has to be communications with somebody who was directly or indirectly asked to provide some kind of service or say or do something on behalf of one of the parties. But this is only granted in relation to TAG, which again is Melissa Nathan's agency. The motion is denied as to the content creator interrogatories propounded by Reynolds, which are moot for the reasons stated above. So because he's not a party to anything right now, they're not going to get communications between the other Wayfarer parties and certain content creators. I remember this has nothing to do with the subpoena to the law firm itself, because Blake Lively is saying that the law firm is acting as like a co-conspirator to this ongoing defamatory campaign. But as of right now, that's a separate docket, and that was filed in California, because they're also wanting to see communications between reporters, media, etc. with the law firm, Brian Friedman's law firm. All right, that's all I got for now. Thanks everyone for watching, and I'll see you all soon.